It seems these days that I am always overly reminded that it is far greater, far more important to be accurate and structured with your statements than to be fast and quick with getting your ideas out. This works in relationships, it works at your job site, it works amongst your social circles, it works everywhere. And I am overwhelmingly reminded with this particular case about this fact. Sorry guys, my dog needed to get out. Let me just zap him real quick.
Please just fucking go, just stop.
Where are you going with this skate informant? Just a few days ago, Supreme replied to Tyshawn's legal team motion to continue, not to dismiss. And there's some good lessons to be learned here that I would like to go over them with you today in this video.
Context. Tyshawn's latest legal response to the lawsuit was likely not his most strategic move. There were some missteps made by him or his legal team, and he needs to turn it around quick, or he may not bring the bag home.
But before we do that, let's look at these decks real quick. Like, I don't care what side of the fence politically you're at, but this has to be unquestionably the most infamous picture of modern culture today, dude. Like, these four, this is a real picture, not AI. Ridiculous, dude. This is like almost illegal to have, but it makes me that much more, to want it. So this was posted by an account called Skateboard Manufacturer. What a unique name, my friends. So given the bio, I think this is one of those like overseas, like maybe Philippines, I don't know, Malaysia, India type of manufacturers. And maybe they print out a bunch of stuff that perhaps isn't like licensed to, yeah, they're just like taking all kinds of random graphics. Some IP here and there that perhaps the anime creators aren't too in agreement with, but nonetheless, you can buy some of these products. So my thoughts with this are maybe I buy a couple. I've already reached out to these people, see if they're actually for sale. They're just doing it like for the clout. If they're actually for sale, I'm going to try to get my hands on a couple of these and maybe like give them away here on the channel. Like somebody comments on the video, I drop an Easter egg or something. I'll just find a way of giving them away. Yeah, dude, this is insane. I just need to have this board, like right, like above my head, somewhere around here. Would be pretty dope, in my opinion. Anyways, back to the topic of today's video. So I've shared this website with you guys in the past. This is the New York State Unified Court System website. This is Tyshawn's case, and we've gone over some of these steps in this convoluted journey of $26 million. And the latest and greatest on this were 3 items, 31, 32, and 33. If some of you recall, on previous videos that I made on the subject, I shared some emails that Tyshawn's team shared to the lawsuit, to the court, saying, look, they gave us the green light. We had permission from Supreme to mess around with these other groups, these other fashion brands. So you can't take action against Tyshawn. You guys said yes. And in these emails, you could see people's full legal name, business address, phone numbers, and of course the email address of these people. And Supreme side was like, whoa, okay, we get you. This is evidence, but let's redact some of this information, bro. Like, you can't have our employees just exposed out there in a legal battle. And the court said, like, yeah, you're right. So they blanked out some of the email addresses, but that was after my video. So we captured the actual email addresses in my previous video. But hey, that was public information, bro. Just because you guys are late to the party does not mean I need to take my video or edit it or whatever. So it's been captured. So I got all that information in my previous video. But anyways, that's what, motion 1A, or for Exhibit A and Exhibit B, where it was to redact, and they've been redacted. So that's been processed, so you can no longer see that information. But then item 33, guys, here is where it gets juicy. So back to the intro of this video, I said it's far greater, far more important to be accurate, to be structured, and very intentional with your statements. Don't just get things out there just to fill the void of silence, just to like a filler that you'll later edit. And unfortunately, as much as I want to see people like Tyshawn win against, big corporations, I think there were some pretty lethal mistakes made here. So, we don't have to go through all the formalities. We know who made this document. It's Supreme's legal team, Tartar, Krinsky, and Droglin LLP. But if you go down to page 7, which I've gone through this document a couple of times already, we'll find this, their preliminary statement. And in here, if you look at this paragraph, it says the following, and I quote, plaintiff's opposition to Supreme's motion, so this is their opposition to Supreme's motion to dismiss. So this is Tyshawn saying, no, let's continue. So their opposition is replete with unsupported and irrelevant factual and legal assertions and does not demonstrate that any of the causes of action have been sufficiently pleaded. So let me pause there real quick. Very intelligently, and rightfully so, dude, there's $26 million on the line. So Supreme's team is saying, yes, Tyshawn's legal team is saying factual statements. They're sharing like legit cases as evidence to support their statements, but they're not related to what's happening right now between us in this very same moment. Like they're not directly correlated. So it's almost illogical to bring those up. They're legal, they're not lies, but it has no impact in this conversation right now. Moreover, plaintiffs rely on cases that are distinguishable, so almost like scandalous cases, off point and contradictory to their arguments, and fail to distinguish and or flat out ignore relevant and applicable case law cited by Supreme. So they're saying, bravo, you quoted a case that happened in the past. What does that have to do with this? So page 8 in this middle paragraph states, and I quote, plaintiffs point to paragraphs of the complaint that purportedly allege false statements, but none of the paragraphs suffice, and many of the referenced statements were not made by Supreme. Tyshawn initially said, yo, I'm being defamed, like wrongfully defamed, because there's false statements going around of me. So that's another reason why I'm suing them. And Supreme's take is like, bro, first of all, the false statements made were not made by people that are Supreme employees. And that's very important. The false statements made were made by people that are not employed by Supreme. These alleged statements are, essentially, Tyshawn was kicked off Supreme. We had to terminate the agreement, had to drop Tyshawn, had to let Tyshawn go. And that Supreme no longer does business with Tyshawn, are neither false nor reasonably susceptible of a defamatory meaning. Extremely important. And then there's a little number 1 here. Here in the bottom it says plaintiff's assertion that the defense of truthfulness cannot be determined on a pre-answer motion to dismiss is incorrect. And their citation of Garcia versus Puccio, 17 AD 3D 199 is misplaced. In that case, the court found that plaintiff had alleged sufficient facts, which, if proven, would establish defamation by implication. Here, sufficient facts have not been alleged. So this is the first example of many, and we're not going to cover them all because there's too much. So Supreme is saying that Tyshawn is unable to state exactly which false statements were made by Supreme employees. Now, the tone of the conversation turns very quickly to an almost chess-like strategy move. Check this out. Moreover, try as they might to dispute this, even if statements advising third parties of Tyshawn's termination were actionable, which they are not, plaintiffs fail to set forth the requisite particulars of a defamation claim pursuant to CPLR 3016A. The only specific individuals to whom plaintiffs allege Supreme or its reported agents made disparaging or defamatory statements is Bolade Banjo, a fashion photographer, and Bracken Darrow, the CEO of VF Corp, which was then Supreme's parent company. I'm going to pause right there quickly. So notice how they're no longer saying, like, well, even if there were false statements, which there weren't any, like now the only disparaging or defamatory statements that were made. Disparaging, which means negative, or defamatory, which means that they'll defame you, you'll lose your status does not automatically insinuate that it's false. They've now like crafted this very intelligent and sneaky way to say, well, let's now talk about the stuff that sure may have hurt you, but is not false in nature. And part of this is protected. And here's how. There's a number 2 here. You see that little number 2? Go to the bottom. As noted in Supreme's initial brief, so they've said this before, any purported communications by Supreme to Mr. Darrell are not actionable. So any type of statements or maybe lingo that may sneak under the table, that make its way to anyone's ears, that involve this gentleman who was the CEO of the parent company of Supreme before it got sold, these are not actionable clauses. Like, you can't sue us because of that. Why not? Because as the CEO of Supreme's parent company, he was not a third party or he had a common interest with Supreme. So as the CEO, and I'm guessing this by extension falls on the shoulders of other executive leadership, like C-suite people in that company, any statements they make could be camouflage or countered with strategic plans. With, dude, I'm the CEO of Supreme. I'm looking out for the best interests of this company and the other ones under this umbrella. You can't sue me for looking out for the best interests of the company. You can maybe sue other people that aren't in a C-suite level position, but not the CEO, because at that point, you're stating that you know what's best for the company from a CEO perspective, which they're not. And Tyshawn's not alleging that he knows what's best for Supreme. He's advocating for himself. So that's not an actionable item. You can't sue the CEO for talking about Tyshawn in relation to Supreme because he's looking out for the best interest of the company. And if that wasn't enough, in page 11 in the bottom paragraph, it states, I quote, "In addition, plaintiffs do not allege special damages as they fail to itemize or provide factual support, simply alleging a round number of $25 million. Let me pause there real quick. So, and I thought this was a little funny from the beginning. You know, that number was quite large to begin with. And sure, yeah, Tyshawn had a $1 million contract, right? $1 million a year just from Supreme alone. And it's somewhat understandable that you may come with a number that's in the millions, but just to say out the gate, 25 million that you owe me on this lawsuit, you have to itemize your numbers, man. I think this is pretty much, or should be, common sense to the average adult out there, right? If you're going to charge somebody for your work, you usually send them invoice and you state, okay, materials, how much it cost me. Labor, how much it costs me, especially if you're contracting people out, and then like the premium that you're adding on top if there's one. You know, you at least explain your journey of thought process. And the same way, if you get an invoice, if you get something submitted to you from somebody else, you expect the contractor to tell you how much were the materials, how much are they charging you, what's the premium. Therefore, you can have an idea if this is a good deal or it's not a good deal. I mean, come on, guys. So here, $26 million because you think you deserve it. I mean, it's cute. And I want Tyshawn, I want the skateboarders to win. But if you're going to get scrutinized by the magnifying glass of the law in New York City, if you're a top skateboarder, you were in Supreme and you're a millionaire, you should at least know where this money is coming from. You should articulate clearly why this amount is the amount that it is to at least elevate your chances. But it seems like Tyshawn nor his team has done this. And as if that wasn't enough, as set forth in the cases cited by Supreme, which plaintiffs fail to distinguish special damages are an essential element, let's scroll down, injurious falsehood and must be itemized. Round figures are insufficient. And then they cite a bunch of other cases, dude. They cite cases where people have tried doing this, where people have alleged special damages. And they have to itemize things. Oh my God. But the reference paragraphs contain only generalized, vague, and conclusory allegations of purported lost opportunities and reputational harm with no facts whatsoever in support and no itemization of damages. Bro. It's like, sometimes, dude, sometimes I almost like get secondhand embarrassment, get a little cringed out because I see these things. And it hurts me because at the end of the day, I don't care how much money Tyshawn has in his bank account right now. I don't care how much street cred he has right now, what kind of shoes, jackets, Louis Vuitton stuff he has. I know this is coming from a skateboarding audience. He was a skateboarder, like born and raised, bro. New York, skateboarding the streets, rubbing shoulders with other skateboarders. Like, man, I feel like getting good counsel these days is difficult, especially if you're somebody in the media, because then you have these legal teams that will come to you and you're just a number to them. Even if they're your legal team, even if they're your representatives, they may still just look at you as a paycheck, as a dollar sign. I don't know if Tyshawn's case is like, we'll pay the lawyers based on the money that I get, I'll give you a percentage, and that's what's incentivizing them. I really hope they're not just charging him like a flat rate no matter what the outcome is, because if that's the case, Tyshawn's already in the hole, man. Obviously, this is not said and done. It's not over, but it's not looking good for him. It's just not. I think that this actually reminds me of this divorce lawyer. I think you guys have seen him on YouTube here and there, like in social media. He was doing his rounds amongst, podcasts and influencers, where he said that he's been practicing law in divorce court and these legal battles with kids and alimony and child support. And there was a woman that essentially lost the case because she was poor and she didn't have a good defender to say the right words, dude.
One that I should have lost. I represented a pimp, very brutally abused a woman who he had children with, and the lawyer on the other side of the case was very inexperienced. And getting a photograph into evidence is very easy. And then you hand it to the witness, or you hand it to the court officer who hands it to the witness, and you say, "I'm showing you what's been marked as petitioner's 1 for identification. Do you recognize that? Does that photograph fairly and accurately depict your face after he beat you up? Your Honor, I'd like it put into evidence." That's it. It's easy. For whatever reason, most likely lack of experience, opposing counsel, I guess, didn't know how to get a photograph into evidence. Now, normally in that situation, a judge will be helpful. But this judge was just not in the mood. Opposing counsel said, "I'd like this to be marked." And then she said, "Could you hand it to the witness?" And she said, "What is that a photo of?" So I did my job. I said, "Objection. She's asking about the contents of a document, not in evidence," which is my job. Judge said, "Sustained." So she said, "Okay, I'm sorry." And she said, I don't know who took it. "What is it a photo of?" Stood up again, "Objection. Asking about the contents of a document, not in evidence." And I could see opposing counsel getting flustered because she didn't know the words. And my internal dialogue at that moment was, just say it. Like, just get it right. Like, just say fair. Does it fairly and accurately depict? Does it like? And I remember looking at the judge and thinking, like, you're letting this happen. You're letting this happen. Don't let this happen. Like, she's poor. That's why she's gonna lose. She's gonna lose because she's poor, and she can't afford a lawyer. And he's gonna win because he can afford a lawyer that knows how to put a document into evidence. And there's something really wrong about that.
I have a pending conversation with a good attorney friend of mine. She was kind of involved in the TK Casahan situation. And she actually specializes in anything that has to do with branding, with, I guess, protecting your brand, your entity, and these type of lawsuits. That's her bread and butter. I forget what the actual, there's a division of that, right? There's a branch of that law, and I'm sorry, Lisa, I'm butchering your profession right now. Hopefully you can correct me, right? Once we connect via Zoom or something. But she's a good buddy of mine, and she agreed to talk about this. So I sent her the link to all these documents. She's going to give me her analysis, her take on this. So that way we have a more precise, okay, what is it really looking like for Tyshawn here? Does he have a chance? And we'll go from there, guys. But this was it. Oh, man, as of now, it's not looking good. And here's the last thing I'm going to say. So this is the last step. Step 33 of this lawsuit, leading up to the court hearing, if we even make it that way, unless it gets dismissed before we give birth to it. That was October 7th, bro. We're now in the 20th. So literally, Tyshawn's team has not made any progress or has not came back to the table with any document in more than 13 days. They've kind of gone quiet. If you look at the dates here, there's been a few gaps here and there in the timeline, but I think this has been the biggest gap, dude. Look at this. September 25th, then it went to October 7th, but now we're going 13 days, almost 2 weeks. Oh man, I really hope the best for Tyshawn, but dude, don't just throw anything into the air, dude. Like when the cops, read you your rights and say anything that you say can and will be used against you. It's not just something they say because it sounds cool. It's because it's real. And right now, they're hanging Tyshawn based on his rebuttal, his initial reply to the request for dismissal. And it's not looking good. The next replies or next step from Tyshawn or his legal team need to be extremely curated, like very carefully crafted before they're made public, because that can break you or make you. Guys, as soon as I see Tyshawn's team reply, I will jump on this camera and give you guys the latest on that. So until then, we'll see what happens. I'm the Skating Informer. You've been informed. My job here is done. And I'll catch you guys on the next one. Peace.